Hi intellectuals, welcome to our channel. In today's video, we will learn about the various theories which explains the relationship between international law and municipal law through a question. Let's get started. The question is, which of the following statement or statements is or are incorrect? A. There are 5 prominent theories of relationship between international law and municipal law. B. According to dualism theory, law is a unified branch of knowledge. C. Monism and dualism are diametrically opposed to each other. D. Wright, Kelsen and Dewey are prominent exponents of dualism theory. The quotes are given below. There are 4 quotes. Now, before getting into the answer, let's now discuss about the question. We all know that international law is otherwise known as the law of nations, is a body of rules and principles which regulates the conduct and relations between the members of the international community. On the other hand, municipal law or state law or national law is the law of a state or country. It is nothing but the internal law of a sovereign state. To put a simple difference between the two, we can say that international law is primarily concerned or it primarily regulates the relations of the members of international community, whereas the municipal law is primarily concerned with the internal affairs or the so-called domestic affairs of the state. The relationship between international law and municipal law have been explained through 5 prominent theories. They are monism or monistic theory, dualism or dualistic theory, specific adoption theory, transformation theory and delegation theory. Now let us have a brief discussion on these theories. The first theory is monism or monistic theory. The word mono comes from Greek which means one. Wright, Kelsen and Dewey are the chief exponents of this theory. This theory states that international law and municipal law are one and the same. According to this theory, man is the root of all laws and all laws are made for men. This theory is substantiated by pointing out that every law, whether it is international law or municipal law, are ultimately made for men, made for regulating the conduct of men. So that is the reason why the proponents of this theory has stated that international law and municipal law are to be treated the one and the same because both have ultimately the main object, that is to make laws for men. The next theory is dualism theory. The word dual means double or having 2 elements. The chief exponents of this theory are triple and ancelotti. According to this theory, international law and municipal law are separate laws. That is, they are different from each other. The proponents have substantiated this theory by pointing out that in municipal law, individual is the subject, but in international law, state is treated as the subject primarily. And in municipal law, the origin of the state law is the will of the state, whereas the origin of international law is the common will of the states. The next theory is specific adoption theory. According to this theory, international law cannot be directly enforced in the field of state unless municipal law permits it or adopts it specifically. That is, municipal law must permit it or adopt it specifically by way of passing appropriate legislation. For example, in India, the Stockholm Declaration of 1972 led to the passing of various environmental legislation such as the Water Act 1974 and so on. The next theory is transformation theory. The word transform means to change. According to this theory, the rules of international law to be applied in the field of municipal law, it should undergo certain changes or transformation. It mainly lays down that the rules of international law should be changed or transformed according to the circumstances and needs in the municipal sphere. The next theory is delegation theory. This theory propounds that there is the delegation of a right to every state to decide for itself when the provisions of a treaty or convention should come into force and in what manner they are to be embodied in the state law. According to this theory, the rules of international law are to be applied in the field of municipal law in accordance with the procedure and system as it is enshrined in the constitution of that state. Now let us get back to the question. The question was to find out which of the statement or statements given are incorrect. So statement A is correct because there are 5 prominent theories which explains the relationship between international law and municipal law. So thus statement A is correct. Statement B is incorrect because we have discussed that according to dualism theory, international law and municipal law are not one and the same. They are treated as different or they are treated as separate laws. So thus statement B is incorrect. Now coming to statement C, it states that monism and dualism are diametrically opposed to each other. Again, it is correct because according to monism theory, international law and municipal law are treated as one and the same, whereas according to dualism, international law and municipal law are treated as separate and different. So thus statement C is correct. Now coming to statement D, it has laid down that Wright, Kelsen and Duguid are prominent exponents of dualism theory. This statement is again incorrect because Wright, Kelsen and Duguid are prominent exponents of monism theory. So in the given quotes, quote 1 which lays down that B and D are incorrect is the answer. So from today's discussion, I hope you would have become clear regarding the theories which explains the relationship between international law and municipal law. Do follow the Courtroom Intellectuals for more updates. Thank you.